No, no.
Now it is stated
Which
losses
container?
without tobacco container weighing 5.51 grams.
5.5,
5.51
5.51 gram,
Okay. Sorry, but
5.51 gram of heroin. Learned counsel for the petitioner has submitted that the present petitioner was apprehended on suspicion that on basis of the voluntary statement recorded during investigation, that the present petitioner used to purchase drugs from the said drug peddler, namely Krishna Saikya alias Tunu. However, it is submitted that nothing was seized from the possession of the present petitioner, and he is in no way connected with the recovery of 5.5 grams of heroin in this case. He has also submitted that in the meanwhile, one of the co-accused, Shri Montu Bora, has already been granted bail by this court by order dated 28/6/2024, passed in bail application number 1789/24. It is submitted by learned counsel for the petitioner that the present petitioner stands exactly in the same footing of the co-accused who has already been granted bail by this court. On the other hand, learned additional public prosecutor submits that though on perusal of the FIR it appears that nothing was recovered from the possession of the present petitioner, however, perusal of the case diary may be necessary. I have considered the submissions made by learned counsel for both the sides and peruse the materials available on record. It appears that apparently no allegation of recovery of any contraband from the possession of the present petitioner is there in the FIR. The allegation made against the present petitioner is only to the extent that he used to purchase drugs from the co-accused Krishna Saikya alias Dhunu. Nothing has been recovered from his possession. Stop. Moreover, considering the fact that the petitioner has already been detained behind the bars for last 50 days, this court is of considered opinion that his further custodial detention may not be necessary if he cooperates in the investigation. Stop. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge Themaji, with following conditions, number 1 and number 2. With above observation, this bail application is hereby disposed of.
obviously.
Number 2.
My lord, I have already taken the instruction. Item 20, my lord.
Okay. Item number?
20.
Item number 20,
Second, first week of August.
adjourned on request of learned counsel for the, you are counsel for
For the
petitioner.
20.
He also submits that he has also already informed the learned counsel for the other side, who has no objection regarding the prayer made for
He only
Adjourned.
requested fixed the.
let this case be listed in the first week of August on a date to be fixed by registry.
All right. Master,
But in this case, record may be called for that.
Heard Mr. H. R. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. Perusal of the scanned copy of the case record of special NDPS case number 19/2023 would be necessary for consideration of the instant bail application. Hence, call for the same. Registry to take steps for requisitioning the scanned copy of the case record. Let this case be listed again on second week of August. The date. No,
May I please have a-
in earlier case, give a fixed date, 9th of August. 9th of. Yes,
Lordship, I am the plaintiff in the suit. My suit has been dismissed. The impugn order is page 60, Lordship.
page
Page 60. For want of.
60.
60, Lordship.
Where it is pending?
It was disposed, Lordship. My suit has been dismissed for want of evidence. Actually, Lordship, on earlier occasion, my evidence has been dispensed with. I filed a petition for recalling of that order. That was rejected. On the 9/11/2023, I submitted an application that I want to file a revision against that order, recalling of order. That was dismissed, Lordship. On the same day, my
No,
suit has
no,
been dismissed.
let me understand. You are aggrieved with order dated
9/11/2023, Lordship. My suit has been dismissed for want of evidence. But both the plaintiff and defendant did not adduce evidence, and the learned trial court has dismissed my suit
9/11/23.
at page 60, Lordship.
When this is a revision under
Revision,
115.
Lordship. Because my suit has been dismissed.
No, but it is barred by limitation.
No, Lordship.
How much time?
3 months.
So when have you filed it?
It was filed on 4/1/2024, Lordship. There has been some defective. It was lying pending there. Notice may be issued, Lordship, because my suit has already been dismissed. Call for the LCR. There is no question of stay.
What will be the date of filing? Which date would be treated? When you remove the defect or you file a defective,
The date of filing, Lordship.
any manner you file. This question may be, okay, we are leaving this question open.
Open, Lordship, at the time of hearing.
Okay. Heard
Mr. D. Kolita.
Mr. D. Kolita, learned counsel for the petitioner. Also heard, no, sorry, petitioner, this revision petition, this civil revision has been registered on filing of an application under section 115 of the Code of Civil Procedure, 1908 by the petitioner impugning the order dated 9/11/2023 passed by learned Civil Judge Senior Division,
Junior Division, Lordship.
Civil Judge Junior Division, Tinisukia, in title suit number 7/2015 within bracket old number title suit number 14/2004, whereby the suit of the petitioner was dismissed. Issue notice to the respondent and call for the records would be necessary or not,
Lordship, necessary, Lordship.
and call for the case record of title suit number 7/2015. from the trial court. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. By registered post with AD as well as by usual mode. List accordingly.
Obliged. May I please, Your Lordship?
এইটা দিছে ভারতত কল করে
Yes,
Yes,
Your Lordship. Lordship, this is an application under 115 CPC. Honor, Lordship, my money suit, there was dismissed on the ground of adjournment. I was the plaintiff therein, plaintiff bank. After I have sent notice to the respondent, they have received the notice. They did not file their WS. An ex parte order was passed against them. Thereafter, on
whether
four-
they appeared,
no, they did not appear.
they did not appear.
They did not appear.
Oh.
Case was proceeding ex parte. On 4 occasions only, I have seek adjournment. That too
But
because
you cannot seek 4 occasion. No
4 times.
adjournment more than 3 times. That is the law.
Lordship, that was on bona fide grounds that the bank manager was busy. Some
Let
audit-
us see the,
imprint order is on page 14, Lordship. Page 20, Lordship, the last order. 4/4/2024.
okay.
By
Then-
petition number so and so paid adjournment today on the ground that the manager plaintiff bank is busy with urgent work and as such is unable to remain present in this court to adduce his evidence. On perusal of case record, it is found that plaintiff side is taking adjournment since 28/11/23 on the same ground. Hence, petition number so and so stands rejected. The case is accordingly disposed of. Lordship, because they have remained absent, they have received the notice. They did not file their WS. That means they have admitted. At least a chance would have been given to me to submit an argument at least.
4 chances were given.
Lordship, all those adjournments were taken on bona fide grounds, Lordship. And the matter is of realization of public money, Lordship. He has taken loan from me and the recovery amount was around 1 lakh something, 1,95,000, the realization amount. So a chance may be given, Lordship, and the case may be restored.
Now, on what ground the order of the trial court would be set aside? What is the error?
Lordship, there is a jurisdictional error.
What jurisdiction?
They might have given me a chance because
No, on that count, there is no fault on the part of trial court.
at least the case
Now, if I impose cost to whom you will pay cost,
to pay to the court, the DLSA,
you will pay
I'll pay a little
how
amount,
much? How much?
whatever your Lordship, 2,000.
Okay,
Because the realization amount is around 1,95,000.
okay, okay, okay. Heard Mr.
Yes, not.
S.
Not.
Nath, learned counsel for the petitioner. This application under section 115/151 of the Code of Criminal Procedure read with Article 227 of the, no, not Article 227 of the Constitution of India has been filed by the petitioner, petitioner, namely Canara Bank, Tinsukia number 2 branch, impugning the order dated 4/4/2024 passed by learned civil judge junior division Tinsukia in money suit number 7/2023. The learned counsel for the petitioner has submitted that the petitioner, which is a body corporate constituted under Banking Companies within bracket Acquisition and Transfer of Undertaking Act 1970, had filed a money suit which was registered as money suit number 7/2023 against the respondents for realization of what loan?
Loan amount.
For realization of loan amount. It is further submitted by learned counsel for the petitioner that in the said title suit, the summons were duly served on the respondents. However, they did not appear before the court, neither they filed any written statement. And accordingly by order dated, by which order? The
10/10/23.
by order dated 10/10/23, the trial court was pleased to direct that the suit would proceed ex parte, and next date was fixed for
Plaintiff evidence.
plaintiff's evidence. Learned counsel for the petitioner submits that thereafter on 4 occasions, the petitioner / plaintiff sought, thereafter on 3 occasions, petitioner / plaintiff sought adjournment on the ground that the manager of the plaintiff bank is busy in urgent bank works. The said adjournment were allowed by the trial court. Stop. However, on 4/4/2024, when the case was again fixed for evidence of plaintiff side, the petitioner / plaintiff again filed an adjournment petition on the same ground, which was rejected by the trial court, and the case was disposed of for want of evidence. Stop. Learned counsel for the petitioner has submitted that the plaintiff, as the plaintiff is a public sector bank,
Public sector.
and as the suit was filed for realization of loan amount which involved public money, the trial court ought to have granted one more chance to the petitioner by even imposing by cost on the petitioner. However, same was not done, and the petitioner was deprived of the opportunity to prove its case before the trial court. Stop. Learned counsel for the petitioner has submitted that the petitioner is ready to adduce evidence for plaintiff side, and considering the nature of the case, even cost may be imposed, which the petitioner is ready to deposit. Though, stop. I have considered the submissions made by learned counsel for the petitioner. Stop. As this case was proceeding ex parte against the respondents, no notice need to be issued to the respondent side in this case. It also appears that though prima facie the trial court was not wrong in rejecting the adjournment petition, however, considering the fact that this case was for realization of loan amount which involves public money, the trial court could have allowed the petition filed by the petitioner, giving it last chance for adducing the evidence subject to payment of cost which would have been imposed by the trial court. Stop. In view of above, for the ends of justice and considering the nature of the case, this civil revision petition is allowed subject to the payment of the cost of rupees 2,000 by the petitioner to the District Legal Service Authority, Tinisukia. Stop. The petitioners shall deposit the cost of rupees 2,000 to the Secretary, District Legal Service Authority, Tinisukia, within a period of how much?
15 days.
15 days from the date of this order. And thereafter, after taking the receipt of such deposit, shall appear before the trial court, the Court of Learned Civil Judge Junior Division number 1 on let me give a fixed date. On 19th August. And on such appearance, the petitioner shall be allowed to adduce evidence. On such appearance, the learned trial court shall restore the suit to file and allow the petitioner to adduce evidence on behalf of the plaintiff side. And this suit thereafter shall proceed accordingly. With above observation and to the extent indicated herein above, the impugned order is interfered with, and this civil revision is accordingly allowed and disposed of.
Highly obliged.
Item number 5.
May I please, your lordship? Lordship, this is an application under section 482 of BNSS Act, praying for granting PRS bail to the petitioner in connection with Borpeta PS case number 207/24.
Yes, please.
Lordship, in connection with Borpeta PS case number 207/24, under section 120B 376 313 of IPC, read with section 6 of POCSO Act.
376 is there.
6 of POCSO is there also.
6 of POCSO is also
Yes,
there.
yes.
Notice will have to go.
Notice have to go, Lords. Informant is the respondent number 2, father of the victim.
Heard Miss
And thus,
N. Das, learned counsel for the petitioner. This application under section 482. Heard Mr.
May I please, your lordship?
Yes.
This is a statutory appeal against the judgment.
What is your name?
My name is Mrinal.
This appeal is against for enhancement, or you are claimant or
Yes, yes.
claimant or insurance company?
Lordship, I am the insurance company.
Okay. Heard Mr. M. What is your name?
Mrinal Dev.
Mr. M. Dev, learned counsel for the appellant. Also heard Miss
P. Borthakur.
P. Borthakur, learned counsel for respondent number 1. This appeal under section 173 of the MV Act, 1988 has been filed by the claimant appellants. Claimant appellant praying for enhancement of the compensation awarded to the claimant by order dated 30/5/2017 in MSC case number 2224/2009 by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Guwahati. Since Ms. Bhattakur has appeared for respondent number 1, no notice need to be issued to respondent number 1. However, as regards respondent number 2 and 3, the appellant shall take steps for issuance of notice to the aforesaid respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. Let the case record of MAC case number 2224/2009 be also called for from the concerned Motor Accident Claims Tribunal. The registry to take steps for requisitioning the aforesaid case record. Let this matter be listed accordingly.
Lordship, I have not received a copy of appeal memo.
You furnish a copy of memo. Today itself, you furnish a copy of memo.
Okay, my lord.
Please, your Lordship.
Item number 7.
Lordship, in item number 7, I am appearing for respondent number 3, insurance company.
Heard Miss, what is your name?
And Buragohai.
Heard Miss N. Buragohai, learned counsel for the appellant. Also heard Miss P. Bhattakur, learned counsel for respondent number
3, your Lordship.
3.
Yes, sir.
This appeal has been filed under section 173 of the, what was the award? It was dismissed, or
Your Lordship, in this case, liability was given upon the owner, your Lordship, as there was no valid policy. And the appeal has been filed by the owner.
by the owner?
It's your Lordship.
Okay, okay. This appeal has been filed under section 173 of the Motor Vehicle Act 1988 against the judgment and award dated 28/7/2017 passed by learned additional member number 2 MACT Tinisukia in MSC case number 38/2011, wherein the Motor Accident Claims Tribunal directed the appellant, who is the owner of the vehicle involved in the accident, to pay the awarded compensation amount of rupees 2,90,000 to the claimant, who is to the claimant, that is respondent number 2. Stop. Issue notice to the respondents. Since Ms. Bhattakur has appeared for respondent number 3, no formal notice need to be issued to respondent number 3. The appellant shall furnish a copy of,
Lordship,
Ma-
we have received.
okay, this line is not necessary. The appellant shall take steps for issuance of notice to other respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the case record of MAC case number 38/2011 be called for from the concerned tribunal. The registry to take steps for requisitioning the aforesaid record. Let this case be listed after 4 weeks.
Obliged.
May I please your lordship?
Yes.
Lordship, a copy of the petition was supposed to supply to the respondent, but due to communication gap, I could not
Yep, ma'am.
supply the same.
Have you supplied now?
We can. Yes, Your Lordship. Today.
You have received.
supply. Yes, today.
You will file objection.
We'll see it. We'll see it. If it's not required, we'll go hearing.
Okay, then we'll fix it again for admission hearing
Lordship,
or
admission hearing.
what is your submission today?
Until I have to go through the petition.
Okay, okay,
He is the petitioner.
okay. Heard Mr. A.R. Som, learned counsel for the petitioner, also heard Mr. V.K. Chandak, learned counsel for the respondent. Learned counsel for the petitioner has submitted that due to communication gap, he could not furnish the copy of the transfer petition to the counsel for the respondent earlier. However, he has furnished the same today. Stop. Furnished the same today to the respondent side. Stop. Learned counsel for the respondent has submitted that as he has received of notice on the aforesaid respondent by registered post with AD as well as by usual mode. The appellant shall also furnish, you have received the copy of memo of appeal.
Which copy?
The appellant shall also furnish the copy of memo of appeal along with the annexures to the learned counsel for respondent number 2 to 11. This appeal who has filed this appeal? Claimant.
No, your lordship, this,
Claimant is respondent number 2.
respond,
Who are you?
your lordship,
She is the wife of the.
No. Who is the appellant?
Appeal was by the owner of the vehicle.
Owner.
Because judgment is that I have violated 147 of the Insurance Act. That is the condition.
So liability is on you.
And it's been imposed. But there is a same case, judgment has been passed by the Honorable High Court, shifting the responsibility to the insurance company.
No, that we will see. Now what you are challenging?
Now I'm challenging it is a wrong judgment, madam.
your lordship, they have, the order was passed in the year 2014. For 5-6 years, it was kept, your lordship, so I had, objected to the delay.
But
it
delay
has
was
been
condoned.
condoned, your lordship.
Delay was only of 75 days.
Your lordship, it is shown 75 days, but they had filed the appeal and had kept it in the, I don't know what happened for, after 6 years notice was, we got the notice. your
Now I'll
lordship.
reply. What happened, my lord?
Okay, okay.
Your
That,
lordship, that's,
No, no,
that is
chapter-
over, your
Yeah,
lordship.
chapter
what-
is over.
How I have convinced the Honorable Court. What happened? We filed in time. But the problem is that the 25,000 we have given, it is it was missing from the record. Then we have filed again new one.
okay.
That
That,
was-
that
They
chapter
just
is
put the
over.
blame on the registry for.
I'm not giving blame. That is in the record itself.
This appeal has been filed under section 173 of the Motor Vehicle Act, 1988 against the judgment and order dated 3/11/2014 passed in MSC case number 448/2008 by the member MSCT, member Motor Accident Claims Tribunal, Sonitpur, fastening the liability on the appellant to pay the awarded amount of rupees 7,71,000 along with an interest of along with an interest at the rate of 6% per annum to the claimants / respondent number 2 to 11. Stop. The appeal is admitted for hearing. This appeal is admitted. Let the case record of MSC case number 448/2008 be called for from the concerned tribunal. The registry to take steps for requisitioning the aforesaid records. Let this case be listed after 4 weeks.
My lord, respondent number 12 is already appeared by L.R. Lutfur Rahman.
No,
Majumdar.
but there is no such order in the main case.
But from the cause sheet, I find
Because
No,
that they have appeared.
no, L.R. Majumdar's name is with name.
Then J. Ghosh is there, my lord.
Jake Hos?
J. Ghosh, respondent number 12.
I don't know, your lordship.
no, you inform them because there is no order of issuance of notice.
No, my lord, they have appeared. There is a Okalatama. Their name has been reflected in the cause sheet today also. Respondent number 12, J.
They
Ghosh.
might have appeared in IA,
Lordship, that may be your lordship.
but there is no order in the main case. Therefore, if they appear on the next date, you may inform the council.
It's a copy.
Let the case be listed after 4 weeks.
Like,
Copy there.
Actually, in this case, we have challenged the quantum of the learned member MSC passed an award for rupees 50 lakhs. 50,960 lakhs and directed to satisfy the same by the two company, New India Insurance Company and the Orient Insurance at the ratio of 50/50. Would the company file it?
No, this
Oriental Insurance,
case is a new case of 2024,
Yes, Lordship.
but record seems to be very old. Why?
because because there was
There was
delay,
a-
delay in filing the appeal, and the case was dismissed for default,
Dismissed
thereafter
for
it
default.
was restored lordship. And the
Yes.
appeal filed by the Oriental Insurance Company was allowed. They have also challenged the quantum of award lordship. We have also challenged the quantum award. So it is a covered case lordship. And the awarded amount was reduced lordship from
Okay, heard Mr. K.K. Bhatto.
lordship. The appeal may be dismissed at this case lordship.
Because already two insurance were involved, lordship. One insurance already judgment has been given.
Lordship, this is the judgment also.
I'm appearing for respond number 1 and
You have
2.
no objection.
I'm appearing for 1 and 2, lordship.
No, but notices to other,
Lordship, only the claimant will be affected, lordship. This covered case, lordship.
no, but today it is for admission.
Admission, lordship.
So the admission says also can,
Where is the record?
lordship,
The record of the,
only we have challenged the quantum award, lordship. They are,
no, for quantum also.
because
This you may show at a later stage. Let the case be admitted first. And notices be issued to the parties. Heard. Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Miss
P. Borwa, lordship,
P. Borwa,
for 1 and 2.
P.
P. Borwa, lordship,
P. Borwa,
for
Learn-
1 and 2.
learned counsel for respondent number
1 and 2. lordship.
1 and 2. 1 and 2 are owner and
No, no. lordship.
claimants.
Claimant, yes, claimants.
1 and 2. Who is appearing for 3?
the trial court also is not appealed, lordship.
Issue notice to respondent number 3, 4, 5, and 6. Issue notice to respondent, other respondents. And call for the case record of MSC case number 651/2008.
Respondent number 4, 5, 6, 7, and 8. Their name may be started. Only the notice in respect of respondent number 3 is necessary, lordship.
Okay. Who was directed to pay the amount?
Lordship.
Who was directed to pay the compensation amount?
Oriental Insurance Company and New India Insurance. The Oriental Insurance has already satisfied as part of this judgment, lordship. Already they have satisfied.
Satisfied the,
Satisfied the awarded amount, reduce the awarded amount. We
No,
also
no.
appeared, we
I-
also appeared in
I
the,
have not understood. This is a separate appeal in connection with the same accident
Same.
by
accident.
some other
Two
claim.
insurance- Two vehicles were involved, lordship, two insurance were there. One insurance already matters, disposed of, lordship, has been settled.
lordship, kindly see the judgment, page
In
number,
the year 2019, lordship.
page number 8, lordship, para number 9.
Now, they have proceeded with another insurance, their insurance.
No, Oriental Insurance Company approached this court
Lordship.
for
Reduction of the awarded. amount.
reduction, challenging the quantum of the compensation.
Quantum.
Then what was the judgment of the appeal? Whether
was
the
reduced-
appeal was allowed?
Appeal was allowed, the awarded amount was reduced from rupees 50 lakh 960 to rupees 19 lakh 24,840. And Oriental Insurance Company is directed to deposit 50% of that amount with 6% interest from the date of filing claims.
Okay.
That is why I paid this
In
amount.
that case, whether New India Insurance Company participated,
Yes, yes, yes.
then why have you filed this appeal?
It was filed, Lordship, prior to dismissal of the appeal.
Then this has become, if he,
Not in fact, sir.
No, in fact, they have proceeded with the matter, Lordship.
the direction of the,
Lordship, kindly see the
no, let me understand. The,
Para number 9.
the, there were two insurance company involved. What was the percentage which was directed 50-50, both? And one company filed a appeal against the quantum of the compensation. That is the Oriental.
Oriental also filed against the quantum award. We also filed against the quantum award.
You filed this one,
Yes.
and
Here appeal was already allowed. That's it. Our appeal was pending. Lordship.
both should have been tagged together.
Lordship,
It was dismissed for default. There,
is why
at that stage, it was dismissed for default. Then it was restored. There was delay, Lordship. That was condoned. And then. Yes. Okay.
Okay, then let the notices,
Notice maybe you should do, Lordship, they have only the claimants, Lordship.
learned counsel for the appellant submits that as the respondent number 4 had also filed another appeal challenging the quantum of the compensation awarded by the impugned judgment, and said appeal was registered as MSC appeal number 21/2016, and same has been disposed of by a coordinate bench of this court by judgment and order dated 21/5/2019. The respondent number 4, 5, 6, 7, and 8 are not necessary for disposal of this appeal, and their names may be struck off. Considering the prayer made by the counsel for the appellant, the names of respondent number 4, 5, 6, and 7, 7 and 8 is struck off from the memo of appeal. Registry to do the needful. The appellant shall now take steps for issuance of notice on respondent number 3 only by registered post with AD as well as by usual mode.
My name may be reflected in the call.
The name of Ms. P. Barua may be reflected against as counsel for respondent number 1 and 2 in the cause list henceforth. Let this case be listed again after 4 weeks.
It is the lordship. Well, in this case, I'm facing a trial under the Special Act Matter and DPS for a possession of a commercial quantity of contraband matter. And I've been in custody for last 1 year, 8 months and 13 days, madam.
1 year?
8 months, 13 days. That comes to madam in days 621 days.
What is the date of your arrest?
Madam, I was arrested on 12/11/2022, forwarded on 13/11/2022, madam. Along with other co-accused persons, madam. Altogether,
What is the contraband?
contraband is heroin, madam.
Heroin, how
Heroin.
much?
14, page 15, column number 4. It is recovered from a vehicle matter 117 soap cases containing 1434 grams of suspected
1.34?
Madam, 1,434 grams. 1,434 grams, madam, 0.53 gram. Yes, and madam, thereafter, madam, on 7/5/2023, 5 accused persons were charged sheeted. And till date, madam, only one PW was examined till filing of this bail application out of 18 numbers of witnesses.
When charges were framed?
Charges were framed, madam, I have made statement, madam.
Lordship, charges frame on 9/10/2023,
9/10/2023,
Lordship, because they have filed a discharge petition.
One out of how many?
18 witnesses, madam.
Whether any co-accused has been granted bail,
Yes, madam. All of the co-accused are on bail, madam,
except you.
except except the present petitioner, madam.
Who are you?
Madam, I was driving that vehicle. That
You are
was-
driver.
Yes, madam. During Naka checking, madam, vehicle was stopped and found 117 showcases from a secret chamber. My humble submission is that, madam, there is a prolonged delay, madam, and 18 and still, madam, 17 witnesses are to be examined. I'm a local person, madam, residing within the jurisdiction of the special court. Karimganj, madam, so any condition, if Lordship may kindly consider my condition and liberty.
Where is the,
Yes, madam.
what is your name?
Madam, Shamil Uddin,
Earlier your prayer was rejected.
rejected, madam. I have annexed those orders, madam.
When it was rejected?
Madam, it was last rejected on 21/12/2023, page 40. Page 40, it starts from page 40, madam. And basically that application was preferred, my lord, because one of the co-accused was granted bail by the coordinate bench. So on the ground of parity, perhaps, my lord, that application was preferred. But this court was pleased to incline, my lord, to entertain that application at that ground.
Yes, Lordship, here the fact of the case is that he is a driver from whose possession during Naka checking the contraband was recovered, Lordship. He is the person. And thereafter, based on his information, other accused are named in the FIR. They tried to find them out, didn't get. Now, Lordship, this here the search sheet was submitted on 7/5/2023, came before the learned court below on your 9/5/2023, and they fixed for cognizance on 15/5/2023. Now, Lordship, cognizance taken on 19/5/2023, and then thereafter, Lordship, that is they have filed the discharge petition, and on the basis of that, on 9/10/2023, the charges were framed against the accused. Thereafter, Lordship, for the first time, that is the issue summons to the PWs after 9/10/2023, and Lordship, this is the they have that is the first date was the on 9/11/2023, the summon was issued for the first time to the PWs, and 5/12/2023 is the date when PWs are absent. Lordship, this is the first date. Then, Lordship, thereafter, PWs on 6/1/2024, it is the second date PWs absent. And now, Lordship, on 22/2024, it is the third date when PW1 is present, but he could not be examined because of the prayer made by the learned defense counsel. That is the prayer that I have flag marked, Lords. On because of that, they could not,
When?
that is 12/2/2024. Lordship, that is the order sheet was available there. I have to flag mark. It is the third day, 20/2/2024. PW1 present, but he could not be examined. Later on, Lordship, in the next date, 19/3/2023, PW1 examined, Lordship, and discharged. Now, Lordship, the next date was for the examination of PW was 1/4/2024. That day, not admittedly, Lordship, PW absent. In the next day, also 10/4/2024, the PW absent, and 3/5/2024 also PW absent. And 29/5/2024, PW2 was examined and discharged, Lordship. And then thereafter, Lordship, sorry, Lordship, on 29/5/2024, this in the similar way like PW1, though PW2 was present, he could not be examined because the petition filed by the learned defense
No,
counsel.
but fact remains, out
Lordship,
of 18, only one has been examined.
Lordship.
So there are 18
Yes,
PWs.
18 to be examined. Right now, Lordship, 2 numbers of PWs were examined.
Till-
And on 2
till
dates,
date.
Lordship, yes, and only 2 dates, though they were present, it is the prayer made by the learned defense counsel. On the basis of that, 2 dates, they could not be examined. That is available on record, Lordship. Lordship may kindly see the order sheet here where the order dated 19/3/2023.
Who is defending the accused persons in?
My lord, there are 4 accused persons who have been granted bail by the trial court as well as by this high court. Now, my lord, all of them, to my instructions, my lord, he is being representing by another set of counsel, my lord, not the defense counsel representing the other co-accused persons.
Who made the prayer?
Yeah, exactly, my lord. That instruction that I have not taken, my lord. So
No.
that I was the one who.
His
took the-
submission is that on your instance, adjournment was granted.
That is,
On defense. So whether it is a same set of lawyer or if different set of lawyer,
because,
then you
my lord,
may get benefit,
my lord,
otherwise not.
so, with conviction, I can say that Malad Mr. Samiruddin, the present petitioner, is represented by another set of counsel.
And on what ground the co-accused were granted bail?
Yes, that I have annexed, Malad, annexed
No, what was the main ground?
Jamil, Malad, that. Malad, 2 of the co-accused, whom who were arrested along with the present petitioner were granted bail because they were arrested based on the confessional state.
Okay.
That is the ground, Malad.
So
based
their
on-
case is a
It
different.
is
Different.
different footing.
So, 2 were granted bail by the learned trial court, my lord. Now, the third, my lord, that is bail application number 2540, he was also on similar footing. There was CDR, my lord, call details record of this petitioner along with the present petitioner, my lord. So, court said that no, that also stands, my lord, on the definition of co-accused statement. So, he was also granted bail. Now, the 4th accused, my lord, it was alleged that the vehicle belongs to him, that Tajuddin, my lord, another co-accused. So this court, my lord, said that only that statement is there, my lord, and one receipt on the document was found in the name of Tajuddin, based on which, my lord, the court, this honorable court granted bail. Other court in it, which, my lord,
But you are on a different footing.
Yes.
I'm on a different footing, my lord. And my submission is that, my lord, solitary ground is that, my lord, I've been in incarceration for last 621 days, my lord. That is perhaps, my lord, a quite long period, my lord. And there is no, my lord, certainty that this trial will culminate in the suit.
Yes.
In a
that
lesser
is-
time, my lord.
That appears because 18, out of 18, only 2 have been examined.
To have been examined, my lord. So,
So there is unlikelihood that the trial would culminate soon. On that ground, he may get a benefit.
But Lordship, in the same way, Lordship, when the PWs were present also on 2 occasions, the 2 court, that was also not examined, Lordship.
because, my lord, the counsel who are representing the present petitioner, I know him personally, and in fact, the counsel representing Jamaluddin, my lord, who has also been granted by, both of them are different set of counsel. That is,
Extra order sheets were there, Lordship.
Which order?
Lordship, Order dated Lordship 2024, the 20th of February. Separate order sheet is there, I think, Lordship, in the above. in the- Only two flag markings.
It is. So,
হয় না?
Hmm.
আছে না? আছে।
22,
20th of February.
20th of February.
whether that petition is there.
Lordship, that I have to find out, Lordship, whether the petition is there. or- Huh? পঠিয়াই কেতিয়াবা petition ৰ copy ও পঠিয়াই। কেতিয়াবা। একেদিনত।
এই যোনটো ৱাৰ্ডিং স্বাধীন ভাৱে দিছে।
কিন্তু 11 তাৰিখ মানে সিহঁতে পলোৱা বুলি কৈছিল। মানে যিদিনা হেৰি কৰিছিল সেইদিনা পলোৱা বুলি কৈছিল।
প্ৰথম স্বাধীন ধৰিছে পিছদিনাখন গৈ দেউতা হাতত আহিছে। মালিকৰ কি পচন্দ আছে তাৰ
মানে হেৰি
গাড়ী
মানে গাড়ী
কিন্তু তাৰ ইমান ভাষাটো হেৰি
Heard Mr. M.A. Ahmed, Learned Counsel for,
চৌধুৰী মানে
sorry, M.A. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. K. Bosho, Learned Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shamil Uddin, who has been detained behind the bars since 13/11/2022 within bracket for more than 1 year, 8 months,
13 days
13 days in connection with NDPS case number, special NDPS case number 159/2022, corresponding to Bajari Chera PS case number 197/2022 under section 21C/25/29 of the NDPS Act, pending in the Court of Learned Special Judge Karimganj. The gist of accusation in this case is court paragraph number 3 from page 36. 36, this is page 36. Para 4 from page 36. Para 5 from page 36. No, para 5 no koribo. Para 5 kati dio. Learned Counsel for the petitioner has submitted that on earlier 2 occasions also, the petitioner had approached this court seeking bail on the ground of prolonged incarceration. However, at that time, the prayer for bail was rejected on the ground that the incarceration undergone by the present petitioner at the time of filing of earlier bail applications were not considered to be long enough to override the embargo of section 37 of the NDPS Act. Learned Counsel for the petitioner has submitted that in the meanwhile, no, has submitted that in this case, the charge sheet was laid on
7/5/2023, madam.
7 on 9,
7/5/2023.
on 7/5/2023. And
Oh, yes, yes.
there are 18 listed prosecution witnesses in the charge sheet. However, till date, only 2 prosecution witnesses have been examined. And there is unlikelihood that the trial would culminate soon. Learned counsel for the petitioner has also submitted that how many co-accused have been granted bail?
4 co-accused are already on bail.
In the meanwhile, 4 co-accused have already been granted bail in this case.
Annexes 7 and 8, I have.
4 co-accused have been granted bail in this case. 2 have been granted bail by the trial court and 2 other are granted bail by the
Court.
coordinate bench of this court. Court paragraph number 6 from bail application number 3881/2023. This quoting is from separate. Learned counsel for the petitioner has submitted that though the present case is a case where commercial quantity of contraband is involved, however, considering the fact that the detention of the petitioner is long enough, that is more than 1 year, 8 months, due to prolonged incarceration of the present petitioner, the fundamental rights guaranteed to him under Article 21 of the Constitution of India would override the embargo of Section 37 of the NDPS Act, number 8 and 9 from 3881. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail on the ground that the co-accused who were already granted bail by the coordinate bench of this court as well as by trial court stood on a different footing from that of the present petitioner. The present petitioner was the driver from whose possession the driver of the vehicle from which the contraband was recovered, whereas the other co-accused were granted bail on the ground of inadmissibility of the statement of co-accused. Learned counsel for the learned additional public prosecutor has also submitted that the trial, there was a delay in framing of charges in this case as the accused persons filed discharge petition, and for considering the said discharge petition, substantial time was consumed by the trial court. Learned counsel for the learned additional public prosecutor has also submitted that on 12/2/24, the witness for prosecution side could not be examined as there was an adjournment petition filed by the defense side, which was allowed by the trial court subject to payment of costs. Hence, the learned additional public prosecutor submits that the prosecution side is not at fault for the delay which has been caused in this case. And accordingly, he opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the scanned copy of the case record of special NDPS case number 159/2022. I have also perused the earlier orders of this court passed in bail application number 2098/2023 on 3/8/2023, as well as bail application number 3424/2023 passed on 21/12/2023, whereby the prayer for bail by the present petitioner was rejected mainly on the ground that at the time of preferring those applications, this court considered the period of detention undergone by the present petitioner was not long enough to get benefit of the prolonged incarceration. Stop. However, now the petitioner has completed incarceration for more than 1 year, 8 months. And till date, only 2 out of 18 prosecution witnesses have been examined. And there is unlikelihood of culmination of trial at the earliest. Code para 17, 18, 19, 20, 21, 22, 23, 24 from 3881. As in the instant case also, the petitioner has been detained behind the bars for more than 1 year, 8 months, and trial is yet to culminate. And only 2 of the 18 listed witnesses have been examined till date. There seems to be very less probability of culmination of the trial at the earliest. Stop. In view of the such aforesaid facts and in view of the observations made by the Apex Court in the rulings cited herein above, where it has dealt with the question of long incarceration of similarly situated petitioners who were before the Apex Court, this court is of considered opinion that in the instant case also, due to prolonged incarceration of the petitioner, the fundamental right guaranteed to him under Article 21 of the Constitution of India outweighs the embargo of Section 37 of the NDPS Act 1985. The petition, and the petitioner is therefore entitled to get bail in this case. In view of above, the petitioner, namely Shamiluddin, is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, one of whom should be the permanent resident of the state of Assam. subject to satisfaction of the following conditions. Condition from 2881. This bail application is accordingly disposed of.
Deeply. okay.
I'm deeply agree.
I'm taking a short break off.
Item number 1.
For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 50,000 each with 2 sureties of like amount with certain conditions.
Item number 14. Review of bail application, my lord. Lordship, find one additional evidence that I filed on 24, my lord, today has been kept, my lord. In the additional evidence, my lord, to earlier judgment of this court, my lord, your lordship passed two orders to the co-accused, my lord. Page number 24 and 21 and 24, my lord, these 2 orders.
CD is there.
CD not available, Lordship.
Today is the third date, my lord.
What is the offense?
But offense is your lordship fine. My lord, what happened? Initially, the petitioner was arrested in connection with Lordship PSS on 6th of June, my lord. There are total 5-6 number of accused, my lord, and total 3 number of cases are there. Lordship PS, Holomuk PS, and Jalukbari PS. This is the Jalukbari PS, my lord. Initially, petitioner was taken into custody in Lordship PS case. Then he was sent, my lord, to judicial custody. During his judicial custody, my lord, he was shown arrest in this case, my lord, as well as in Holomuk PS case also.
In this case, when were you arrested?
On 15th of June, my lord. 15th June, my lord. He was
15,
shown arrest and taken into police remand. Then again, my lord, he was forwarded to judicial custody.
15 June. And when you were actually arrested in
15th on 6th of June, my lord.
6th of June, in
6th of
connection with which case?
Lordship PS case, my lord.
Number?
Lordship PS case number. In your lordship's order also it is reflected, my lord. Lordship may kindly come to page number.
No, PS case, what? Tell me the number.
My lord will find page number.
Whether Mr. Bosho case diary would be necessary or it can be disposed of.
My lord, already 2 of the co-workers already has been granted bail by your lordship.
In this case,
In this case, my lord. Lordship will find page number 21, my lord.
Lordship, here, the
Page number
petitioner-
21 and 24. In the additional affidavit, your lordship will find 2 of the order.
no, but they were granted bail after perusal of the case diary.
Yes, in 21, after perusal of the bail, or case diary, and 24, my lord, without perusal of the case diary, my lord. And he is the main accused. In page number 24 order, he is the main accused in all the cases, my lord. And petitioner also, my lord, petitioner has been granted bail in other 2 cases by the coordinate bench of this court, my lord. He is the main prime accused, my lord. This page number 24 order, my lord. Additional affidavit, my lord. And he was, my lord, allowed to go and bail on 28th of June, my lord. Almost one month back,
Why you are saying that he is the prime accused?
my lord.
On what basis you are saying that he is the prime accused?
Lordship,
FIR mentions his name.
Yes.
Manoj.
my lord, page number 16 of my bail application, my lord. He is listed as accused number 1. And your lordship will find the FIR page number 13.
In this case, how many accused are there?
Total, my lord, 7, my lord. 6.
How many are on bail?
Up to my information, 4 already have been released, my lord. Even the accused number 2 in page number 16, my lord, Ojit Bashfor. Even 4-5 days back, my lord, he came to this court, my lord, and actually even he also met me that he was also granted bail in all the cases, my lord.
Yeah, Lordship.
May Manoj Basfor is named accused.
Manoj Baspa, same time the present accused petitioner also, Ramzan Ali.
From the
And both are the allegation is same against both the persons. Lord.
and my today is the third date, my lord. Is it not condemned on the part of the police, my lord? Obviously, my lord, this is contempt, my lord. Why are you just complying with this with the direction of this court, my lord? Then I may be directed to appear today itself with case diary, my lord. Even the main, my lord, in other 2 cases also, the coordinate bench of this court, my lord, granted bail, my lord. Lordship may find the order, my lord. My lord, I'm submitting to 2 of the orders.
Manoj Basfor and Ramzan Ali stand on same footing.
Yes, same petitioner.
So Manoj Basfor has been granted bail. How many days you are behind the bars?
50 days, my lord. 50 days.
50.
50, my lord. Counting from 6th of June, my lord.
And from 15 June?
It will it's still more than 40 days, my lord.
No, tell me exactly.
My lord,
Use your,
my lord, I'm calculating.
15 June. No?
15th of June, my lord.
okay, heard. Mr. You tell me the,
MA Islam, my lord.
no, not your name, but the days. Heard Mr. M.A. Islam, learned counsel for the
My lord,
petitioner.
41 days as on today, my lord.
Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 4 483 of the BNSS, 2023 has been filed by the petitioner Ramzan Ali, praying for allowing him to go on bail, as he has been detained behind the bars since 6/6/2024 for last 50 days. Stop. It is submitted that he has been shown arrest in connection with Jalukbari PS case number 99/2024 on 15/6/2024. And from 15/6/2024 also, 41 days have lapsed.
41 days.
The gist of accusation in this case is that on 26/2/2024, one Raju Deka had lodged an FIR before the officer in charge of Jalukbari Police Station, Inter Alia, alleging that the informant who had an account in State Bank of India was given assurance by the present petitioner and one Manoj Basfar of giving loan of rupees 10 lakhs. The informant accordingly converted his SBI account accordingly transferred his SBI account to Punjab National Bank, and the said bank sanctioned a loan of rupees 10 lakhs to the petitioner. Stop. It is, however, alleged in the FIR that the present petition sanctioned the loan of rupees 10 lakhs to the informant. Stop. However, it is alleged that the present petitioner, along with co-accused Manoj Basfar, withdrew the said amount after taking the signatures on a check from the informant by fraudulently, by conspiring to defraud the informant of the money. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since last 50 days in connection with Latasil PS case number
30/24.
30/2024. And he has been shown arrested in Jalukbari PS case number 99/2024 on 15/6/2023 and has completed 41 days behind the bars in this case also. Stop. It is submitted by learned counsel for the petitioner that in the meanwhile, co-accused Manoj Basfar and Ponindra Kumar have already been granted bail by this court. And considering the long detention of the above named petitioner, he submits that further custodial detention may not be necessary for fair completion of the investigation. He also submits, learned counsel for the petitioner also submits that the petitioner is ready to cooperate in the investigation. Which was passed without perusal of the case diary.
Page 24, my lord. 24 order, my lord. Page 24, additional evidence.
Case diary was perused. You go through. You have made wrong submissions. Stop. Learned counsel for the petitioner. Learned counsel for the
Yes, my lord.
additional public prosecutor submits that perusal of the case diary would be necessary. Hence call for the case diary fixing.
Short date, Lords. 31st of July, Lords.
31st July for case diary. I would have granted, but you have made wrong submissions.
My lord.
Therefore, you have to wait till 31st.
I'm sorry, my lord. Perhaps, my lord.
On 31st, we will consider it.
Yes, Lord.
I'm sorry. my lord.
Duly applies.
On 31st. Yes.
May it please your lordship. My lord, appellant hearing was the defendant in the original suit, and concurrent finding is there against the defendant. The plaintiff filed a suit for realization of money of rupees 6
You are
lakh,
caveator.
yes, which was paid for, my lord, purchasing a plot of land. And subsequently, his case is that subsequently, the defendant could not deliver the possession of the land, and he intended to sell the said plot of land by stating that he has right title interest over the said plot of land measuring 3 kotha situated at Bhorbari, my lord, against
No, you have to repeat again.
my lord. The plaintiff filed a suit.
Plaintiff means the appellant.
Plaintiff-
You are
no,
plaintiff
my
or
lord, I am
defendant?
defendant. I
Defendant.
am defendant.
Okay, plaintiff filed the suit before.
Suit, my lord, for realization of money
Okay,
of rupees 6 lakh,
6 lakhs.
6 lakh,
Okay,
which was paid as consideration for a plot of land. On the basis of the representation of defendant that he has right title interest over the said plot of land measuring 3 kotha situated at Hengabari.
okay.
And it is
Defendant
also,
means you.
my lord,
Okay,
and it is also case of the plaintiff that both the plaintiff and defendant were trained. So he did not verify the land record, etc. And paid entire amount of consideration of rupees 6 lakh to the defendant. And accordingly, an agreement was executed, that is exhibited as exhibit 1. May I submit the certified copy of the exhibits, my lord? Before we get
no, but before that you make your submission.
because these are relevant, my lord. And his case is that, my lord, initially he visited the said plot of land on 25th February 2012. And thereafter, he paid the entire amount of money on 16th to 2013 by way of giving 3 numbers of checks. And subsequently, on 5 February 2014, when he went to the plot of land sold by the defendant for measurement, my lord, some people of the locality resisted him and threatened not to come there again, stating that the defendant has no land there. That is the case. And subsequently, my lord, he approached the defendant and the defendant assured to return the money, but he did not return. Thereafter, the plaintiff issued a return notice to which the defendant issued reply. And case of the defendant is that, my lord, he was the possessor of a plot of land measuring 1 kotha 10 lesa situated at Hengrabari. That is the government land. My lord. And the plaintiff intended to purchase that plot of land at the consideration of rupees 6 lakh. Accordingly, the defendant received the said amount of rupees 6 lakh. And subsequently, my lord, when the government evicted from that plot of land,
Evicted whom?
the defendant, my lord, defendant was already, possession was already delivered to the, my lord, the plaintiff. And he also constructed one tin sally by taking the possession over that. And subsequently, since it was a government land, my lord, so government evicted the plaintiff from that plot of land. And thereafter, my lord, the plaintiff claimed the consideration amount of rupees 6 lakh. Initially, my lord, he issued the pleader notice where the plaintiff himself stated that he was evicted from the said government plot of land. And his story was that the defendant lent the money, borrowed the money from the plaintiff, stating that he will give the plaintiff a plot of land. That was the story of the plaintiff in the pleader notice. And subsequently, the case has been filed by making a different story that he intended to purchase a plot of land, and the defendant represented that he has a right title interest over 3 kothas land, and that was intended to sell. And the plaintiff, not being aware about the right title interest, he paid entire amount of consideration of 6 lakh, and he never took possession of the said plot of land. And subsequently, when he went to the plot of land after payment of money, after 2 years of payment of the consideration, then he only came to know that defendant has no land at that area. And thereafter, he claimed the money. And it is the case of the plaintiff that defendant assured to return, but subsequently didn't. So, my lord, there is 2 stories.
Whether any agreement was there?
My lord, that is
Written-
exhibit 1. That is why I would like to submit the exhibits. My lord.
Okay. No, I'll see.
Because the agreement did not reveal that the defendant has right title interest over the said plot of land. The agreement is very simple, 4 lines of agreement that the defendant has received a sum of rupees 6 lakh for as consideration against a plot of land. Against a plot of land, that is not mentioned, nowhere mentioned that he has right title interest over the said plot of land.
Okay.
And it is also, nothing is, my lord, revealed in that agreement. So, my lord, but he is claiming that the defendant has played fraud with the plaintiff by stating that the defendant has right title interest over the said plot of land, and on the basis of which he paid entire amount of consideration of rupees 6 lakh without any inquiry, without any verification of revenue record.
The plaintiff filed this money suit on
Money,
this,
money, sir.
taking the plea that it was a loan.
No, my lord. In
He-
the
he-
pleader
that-
notice, it was a loan.
Now, in the
But
suit
in the suit, my lord, as a consideration, my lord.
for,
He paid as consideration for the plot of land measuring 3 kotha, which is also not mentioned in the agreement.
okay. but which was not for execution of a sale deed.
No, my. Because my lord,
Okay, how first trial court decided this would?
trial court decided that, my lord, the defendant has intentionally concealed that he has no right title interest over the said plot of land. And the plaintiff, without knowing that the defendant is having no right title interest over the plot of land, paid the entire amount of consideration. So the defendant has played fraud with the plaintiff, and accordingly, my lord, decreed for realization of 6 lakhs along with, my lord, interest at the rate of 6% and 1,50,000 as compensation. That is a decree. And thereafter, my lord, the defendant filed the appeal against the trial court judgment, my lord.
No, where is
And that is
the,
also,
where is the judgment of the trial court?
trial court is, my lord, is page 26, my lord. There, my lord, 4 numbers of issues have been found at page 32. And relevant portion, my lord, comes from page 32, my lord. May I read, my lord?
No, what was the decision on issue number 2? Issue number 2.
Starts at page 33, issue number 2.
Finding is at page 39, paragraph 13. Discussion is from page 32.
Court ultimately held that you fraudulently
My lord,
projected yourself to be in possession of the land and thereby plaintiff parted with his 6 lakhs rupees. Okay. Then what plea you took before the first appellate court? What was decided? Where is the first appellate court's judgment?
ground is at page 56, my lord. Before the learned appellate court below, my lord. That the learned lower trial court has erred in law and facts in deciding the suit. That the court below failed to appreciate the evidence on record on its proper perspective. That the learned trial court had wrongly held that the defendant had fraudulently projected himself as the owner having the title over the said land. Whereas the learned trial court ought to have held that the plaintiff knew that the defendant had no title and still the plaintiff purchased the possession of the land. That the learned lower trial court ought to have dismissed the suit. Those were the grounds, madam.
What first appellate court held?
My lord, upheld the judgment, my lord.
Holding that it was correctly decided.
My lord, my lord.
Now, what is your substantial question of law which is involved in this appeal?
Firstly, my lord, first appellate court has held that the agreement was void. That is a my lord. Page 66, paragraph 35, my lord. The contract between the plaintiff and defendant is void. My lord, the section 2(z) of the Indian Contract Act define that an agreement not enforceable by law
is said to be void. So if the agreement is void, my lord, then it is not enforceable, and then no relief can be granted on the basis of said void agreement, my lord. So my first substantial question, proposed substantial question is that whether the learned courts below erred in law in granting decree for recovery of consideration on the basis of an agreement, that is Exhibit 1, declaring the agreement as void. And my lord, if relief is granted on the basis of an agreement, that should not be beyond the terms and conditions of the agreement. So my second substantial question is that, my lord, whether the learned courts below erred in law by granting relief on the basis of an agreement, Exhibit 1, beyond the terms and conditions of the agreement per se. Now, my lord, fraud is defined in section 17 of the Indian Contract Act, and that portion is also relevant with section 19 of the Indian Contract Act, my lord. So, my lord, section 17 of fraud defined that fraud means and includes any of the following acts committed by a party to a contract or with his connivance or by his agent with intent to deceive another party, dare to or his agent, or to induce him to enter into the contract. Thus, one, the suggestion as a fact of that which is not true by one who does not believe it to be true. Then, second, my lord, the active concealment of a fact by one having knowledge or belief of the fact. Third one is a promise made without any intention of performing it. Fourth one is any other act fitted to deceive. Five one is any such act or omission as a law specially declares to be fraudulent. Here, explanation is there, my lord. Mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud. Unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. Here, my lord, the stand of the plaintiff is that the defendant stated he has right title interest over the suit, over a plot of land, my lord. And defendant's stand is that plaintiff was aware that he has no right title interest over any plot of land, but he has possessory right. And here is no document is exhibited by the plaintiff for substantiate that part that the plaintiff has stated or represented that he has right title interest over the land. And his death statement is also not corroborated by a single witness, my lord. So, my lord, he failed to discharge his burden of proof, my lord, as per section 101 of the Indian Evidence Act. Now, my lord, may I read, my lord, exception to the section 19 of the contract, which is relevant to, my lord, interpret the section 17, my lord. I am reading entire section 19, my lord. Voidability of agreements without free consent. When consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. A party to contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed and that he shall be put in the position in which he would have been if the representations made had been true. Now, my lord, exception, if such consent was caused by misrepresentation or by silence, fraudulent within the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Now, my lord, if I represented before the plaintiff that I have right title interest over the said plot of land, then it is a person of ordinary diligence can also reveal that by visiting the revenue record, my lord, by perusal of revenue record or the revenue authority, that whether the defendant has any right title interest over any plot of land at that area or not. But that is not done by the, my lord, plaintiff. And he paid entire amount of consideration without knowing the status of the, my lord, land he is going to purchase. That is not, my lord, believable. So, my lord, my third proposed substantial question of law is that whether learned courts below erred in law by holding that the appellant defendant committed fraud despite having no ingredients of fraud as defined in section 17 of Indian Contract Act 1872 and in contrary to the exception provided in section 19 of the Indian Contract Act 1872. Now, my lord, I have already stated that submitted, my lord, since an ordinary person of ordinary diligence, my lord, ordinary prudence, can easily, my lord, reveal that whether a person who claimed to be a owner of a portion of land is having right title interest over that plot of land or not. It was the duty of the plaintiff to verify or to see any document regarding the plot of land which is going to be purchased by him. Or he has also to, it is also duty of the plaintiff to.
The question of your proposed substantial question you have, which you have mentioned at clause 4,
My lord,
is not a substantial question.
my lord.
About above 3, I will hear him, but fourth one is not a.
But, my lord, the application of preponderance of probability,
That
that
is
was
a-
not properly, my lord.
That is not a substantial question.
That is not. But, my lord, height is necessary, my lord, but for substance stating, my lord, substantial question number 5, my lord, record is required, my lord, because it will reveal from the evidence only whether the judgment and decree impugned are vitiated by perversity for wrong appreciation of evidence and misinterpretation of law and facts.
No, perversity. Not considering the evidence, which is
My lord, that is why, so.
wrong consideration. The court may reach, one court may reach at a particular conclusion. Another court may reach on the same fact on a different conclusion. This is not perversity. Perversity is if you have not considered the evidence which was, that is not the case in the instant case.
No, my lord, perversity is also that, my lord, if evidence says otherwise, but finding is, my lord, held otherwise, my lord, that is also perversity. So that is there, my lord. Because one finding of the, my lord, trial court, that the plaintiff was never in possession of the suit land, my lord. That particular land in question, my lord, that has been, my lord, altered in the by the appellate court, my lord.
Yes. Anything else? What is your submission?
Lordship, in the plaint, Lordship, at paragraph 12,
At page,
paragraph 12, page 12, paragraph 4 of the plaint.
yes.
Is specifically pleaded that on 25/12/2012, both the plaintiff and defendant went to Guwahati to look the land of the defendant at Borbari, Guwahati. After arriving Guwahati, the defendant showed the plot of land measuring 3 katha at Borbari, Upper Hengrabari, Guwahati to the plaintiff and told he had right title interest over the land. The plaintiff found the land suitable for to fulfill his purpose and agreed to purchase it. After negotiation, the price of the land was fixed at 6 lakhs. In reply to this paragraph at paragraph 19, those statements are not specifically denied.
Where?
Page 19. Written statement. Page 19, paragraph 24 is the reply. The contents of paragraph 4 are designably made out to beat a fragile story just to embarrass other. The right title interest of a person over any plot of land are intimated only through proper documents. Oral assertion is never sufficient to enter into an agreement for transfer. Plaintiff is to due to the cheated who is in a fair instance knows well to approach the civil court in his hour of need. There is no specific denial regarding that he has not stated that he had no right title interest. He has not said anything about that. These statements are not specifically denied. In fact, if we look into the judgment of the trial court, issue number 2, paragraph 34.
At page,
Page 34. Page 34, paragraph 7.
yes.
Paragraph 7. It has been recorded. In fact, the defendant has also admitted in his written statement as well as in his evidence as DW1 that fight exhibit 1 and through check he has received rupees 6 lakhs from the plaintiff. He also admitted that exhibit 1 is in the exhibit 1 there is no mention about the sale of Sarkari land and that he received money for it. From the evidence record on record of PW1, PW2 and DW1, it is very clear that defendant received rupees 6 lakhs from the plaintiff towards sale and purchase of land of the defendant by the plaintiff plaintiff. Exhibit 1 is proved by the plaintiff accordingly. Now the question is whether the defendant has fraudulently cheated the plaintiff to part with his property of rupees 6 lakhs by projecting the false fact that he is in occupation or possession of the land at Borbari, Hengrabari, Assam. The defendant came up with a story that he is a member of Sankardev Shilpi Samaj, Hengrabari, and as a member of the society, the defendant is in occupation of 1 Katha 1 Lesa of land since 1990. For allotment of the land, the defendant along with two co-sharers, Pankaj Kolita and Dr. Jagadish Kolita applied to the Revenue Authority for allotment of their respective share of occupancy under Dag number 602 of village so-and-so. He also pleaded that Srimanta Sankardev Shilpi Samaj also made an application to the Revenue Authority for allotment of the respective share of occupancy in Dag number 602 of Hengrabari on 28/6/2006. The defendant took plea that he is in fact given possessory right to the plaintiff during the first week of January 2013, and the plaintiff also obtained occupation of the 1 Katha 10 Lesa land under Dag number 602 of village Hengrabari. According to the defendant, the plaintiff is aware that the land is Exona, and he received rupees 6 lakhs for delivery of the occupancy stroke possession of his share of land to the plaintiff. Now the question arises as to whether the defendant, though pleaded these facts, have been able to discharge his burden of proving these facts before the court. It is interesting to note in this case, the evidence of DW4. This DW4 appeared before this court, bringing with him the proceeding book of Srimanta Sankardev Samaj Shilpi Samaj, admitting that he issued the certificate on 20/08/2006 to the defendant, Hemanta Talukdar, in the capacity of Secretary of Sankardev Shilpi Samaj, which is Exhibit B. He also acknowledged the Exhibit E to have been issued in the name of Bhavesh Kolita, the plaintiff, on 25/1/2013. There are only 2 documents which are exhibited from the side of the defendant, and the defendant number 1 through DWs. When defendant number 4 was examined, it becomes very clear that the land of tag number 602 is a government land and the same is not allotted to anybody. It is also become clear from his evidence during cross-examination that Bhobesh Kolita plaintiff never submitted any application for taking membership of Shankardev Shilpi Samaj, but he was introduced to the Samaj by Hemanta Talukdar on his resignation. Srimanto Shankardev Shilpi Samaj did not authorize Hemanta Talukdar defendant in writing to any act on behalf of the Shankardev Shilpi Samaj. In the year 2016, the construction over the land of Dag number 602 has been removed and evicted. It is clear from the evidence that he does not know which land was proposed to be sold by the defendant Hemanta Talukdar in favor of Bhobesh Kolita, the plaintiff, by entering into agreement. It is further made clear by the DW4 that the defendant never in writing informed about transfer of his share to the plaintiff being member of Shankardev Shilpi Samaj. Members of Shankardev Shilpi Samaj amicably divided 1.5 katha each, but there is no writing to that effect. He also made it clear that Hemanta Talukdar did not deposit rupees 6 lakhs so received from Bhobesh Kolita plaintiff with Shankardev Shilpi Samaj in the proceeding book or any other documents of Shankardev Shilpi Samaj does not bear signature of Bhobesh Kolita, the plaintiff. Thus, from the evidence of DW4, it is crystal clear that the defendant is a member of Shankardev. The defendant is a member of Shankardev Shilpi Samaj. The proposed land which he wanted to sell is not allotted to him or anybody else by the government. It is a government land and there is no endorsement or acknowledgement in the proceeding book or other documents of Samaj regarding the share of the defendant or his right to do any act on behalf of Samaj. It is clear that 1.5 katha land is shared by the member of Samaj, but whether the defendant got share or not is not at all clear from the evidence of DW4. Evidence of DW4 has therefore shown the false nature and character of DW1 defendant, and therefore the defendant cannot be believed at all. In addition to it, the defendant also adduced the evidence of DW2 and DW3 regarding occupancy stroke possession of the plaintiff over the land sold by the defendant to the plaintiff. It is seen from the evidence of DW2. It is seen from their evidence that DW2 went to the extent of giving false evidence that the plaintiff was occupying the land which was sold to him by the defendant by constructing houses thereon. DW1, to support his pleaded case, brought DWs to prove that defendant gave possession stroke occupancy right to the PW1 plaintiff. But on perusal of the evidence of DW3, it is very clear that he never went with the defendant Hemanta Talukdar to give delivery of the possession of the land at Guwahati. Thus, in the light of evidence of DW3 and DW4, it can be hardly believed that defendant got allotment of land 1 katha 10 lesa and he delivered possession of the same to the plaintiff ever. Coming to the evidence of DW1, who was cross-examined, it appears that the defendant himself does not know whether the land which he proposed to sell under Dag number 602 belongs to him or not. It is admitted by the defendant number 1 as DW1 that he has no identity card as member of Shankardev Shilpi Samaj. Whether the plaintiff is living in the land under possession of Hengrabari, possession at Hengrabari, that also he does not know. He also admitted that he does not know about the length and breadth of the land taken possession by the plaintiff, and he has not given possession to the land, possession of the land to Bhobesh Kolita by meets and bounds. Thus, from the evidence of the DW and his witnesses, it is clear, very much clear that on the date of taking money, promising to sell the land to the plaintiff, the defendant as DW1 had full knowledge that he has no such land allotted in his name by the government or by the Shankardev Shilpi Samaj. The land was never given possession to the plaintiff. The land shown by the defendant to the plaintiff, and on the basis of when the plaintiff went to measure the land to construct house, over it he was restrained by the neighbors of the locality. In view of the above, the court found that fraud is practiced by the defendant on the plaintiff by making the plaintiff to part his property of rupees 6 lakhs on the false promise of the false promise of selling land to him at Guwahati. The defendant as DW1 has also falsely adduced evidence of DW2 and DW3, has clearly stated that he never went with the defendant to give delivery of possession of the land at Guwahati to the plaintiff. For hiding one false from the discord, the defendant built up a mountain of false facts, and the same are glaring from his own evidence as defendant DW1 and from the evidence of DW3 and DW4. In fact, the defendant stroke DW1 has no land at all at Guwahati, and the pleas which are taken by him that the plaintiff was in possession and he has been evicted from the evicted by the authority in due course are false and imaginary. The defendant has clearly admitted about taking of rupees 6 lakhs from the plaintiff by check, and these facts is also proved by the plaintiff as well as defendant as well as his witness PW2 in clear and cogent manner. So
This is trial court's judgment or appellate court?
the trial court judgment.
But that part is, my lord, appreciated otherwise by the appellate court.
Lordship, in my humble submission, when the defendant sold the land to the plaintiff and received the money, he never disclosed that whether this is a Sarkari land or whether this is a Patta land or anything. He received the money and he sold the land to the plaintiff that this is your land. When he went to the land, then some neighbors of the locality restricted him. Then when he came to the defendant about to inquire into the matter, the defendants could not deliver him possession, and he asked the defendant to return the money. The defendant did not return the money, and thereafter he filed a suit. So basically, it was the land was given to Shankardev Shilpi Samaj, and but the defendant is neither a member of the Samaj nor he had anything to do with the Samaj. So he could not deliver the land, but he took the money from the plaintiff. So that is how he played a fraud upon the plaintiff. And regarding the practice of fraud, Lordship, he concealed the fact that whether the land is a Sarkari land, or he did not even say that the land belongs to Samaj or all.
Regarding the substantial question of law,
Regarding substantial questions of law, Lordship,
whether it is,
those are already been discussed by the learned trial court, Lordship. So
your submission is no substantial
there is
question
no
of law.
substantial questions of law. And in fact, regarding the agreement and the terms and condition and everything, and regarding fraud, the trial court has already discussed.
Okay. Heard. You have anything to say?
My lord, whatever part my learned friend has, my lord, submitted, my lord, that has been contradicted by in the appellate judgment, my lord, at page 63, my lord. Paragraph 29. From paragraph 29 onwards, my lord. That the learned counsel for the defendant appellant had contended that DW2 had specifically stated that he saw the ex-alley house of the plaintiff over the land, and so it has to be held that plaintiff was in possession of the disputed land. I have perused the evidence of the DW2, and he had deposed that he does not know the description of the land in question. However, once he went to the land in question in the year 2014, and then he saw that plaintiff was filling earth in the land with a tractor, and there was ex-alley house. The above portion of the evidence of the DW2 is consistent with the evidence of the plaintiff, because the plaintiff had himself admitted in his plaint that on 5/2/2014, he went to the land in question and took measurement of the land to construct residential houses, and then some persons of the locality came and obstructed him. Thus, it is seen that it is an admitted fact that the plaintiff took possession of the land. But the dispute is not whether the plaintiff took possession of the land, but the matter in issue is as to whether the defendant had fraudulently induced the plaintiff to believe that the land in question was owned by him and he had transferable right, title, and interest over the disputed land. My lord, in the written statement and also in reply, he categorically stated defendant that he has only possessory right, not right, title, interest. He never claimed that he has.
How appellate court dealt with this issue?
My lord, but the trial court held that the.
No,
plaintiff-
how appellate courts,
My lord,
what appellate courts said thereafter?
in my considered opinion, the fact that the plaintiff was filling the earth or constructed actually house over the land in question does not in any way lead me to infer that he had the knowledge that the land was Solkari house land, or the fact that the defendant did not fraudulently induce him to believe that he was the owner of the said land. In view of the above discussion, it is apparent that the plaintiff was fraudulently induced by the defendant to believe that the defendant was the owner of the land, having title over the land, same, and the above fact is apparent from the exhibit 1, wherein the defendant had admitted that he had received the consideration amount for selling land. The exhibit 1 does not mention that the sale consideration was received for selling only the possession of the land, not for transferring the title over the land in question. In view of above discussion, it is held that the learned trial court had rightly discussed the materials on record and had arrived at a correct decision that defendant had played fraud upon the plaintiff.
Judgment and to read as a whole, finally the court has declared that the defendant has played a fraud upon the
And
plaintiff.
it is therefore held that as because fraud was played upon the plaintiff and there was no add item in respect of the consideration of the contract, the entire transaction and contract between the plaintiff and defendant regarding the sale purchase of land in question is void. And thus, the plaintiff is entitled to get a refund of the amount of rupees 6 lakh, which he had paid to the defendant. It is further held that learned trial court had rightly held that the defendant had played fraud upon the plaintiff, and so the defendant is entitled to compensation of rupees 1,50,000 along with interest at the rate of 6% per annum from the date of filing of the suit realization. That was the finding of the above.
Okay. Heard Mr.
UK does.
UK Das, learned counsel for the appellant, also heard Mr.
D. Chaudhary.
D.
D. Chaudhary.
D. Chaudhary, learned counsel for the caveator slash respondent, only sole respondent. Sole respondent. Let this case be listed for delivery of orders on Monday. On Monday, I will pass orders regarding whether to admit your appeal or not. Monday, that is 29.
Much.
May it please your lord- May it please your lordship. My lordship, this is second round of litigation. The main moot question is that, my lord, whether a bongia that is used to cross two fields can have a right.
Whether what?
Bongia, my lord. Bongias are used in the village, in the paddy fields to cross from one paddy field to the other paddy field. It's called as bongia, small path of land
Oh.
between two agricultural land. So this is second round of litigation, my lord. So what is the respondent here has done? They have claimed right of easement under section 24 of the Limitation Act, saying that they have been in use of that land and there is no alternative path. As such, they should be given the right over that land. It is a bongia land, my lord.
Bongia means a way.
Yeah, way, it's a way, my lord. It's a way between two paddy fields.
Okay.
My lord, I have enclosed, my lord, section 24 very clearly says that that there should be an indefeasible right and there should be no alternative way to reach the other place. Whereas, my lord, the evidence.
But I've marked it, my lord.
What is this?
My lord, this is the evidence of the DW1. Sorry, my lord, evidence of
No,
DW3.
what is your name?
My lord, her name is
No, what
Probin
is-
Neo.
What is your name?
My lord, SP Sharma, my lord.
So don't be in hurry. We'll take it up
My lord,
because now there is,
I understand.
I have a division bench at 2.
Yes. After rising of the division,
After Rajin,
Well,
we'll
we'll
continue.
wait. If time permits.